So tonight we're here for a training of the Development Commission and the Planning Policy Commission. And we also have staff from various city departments. And you have agendas, so I think you can sort of see the order that the city clerks, Tina Eggers and Tisha Gieser, are going to speak, followed by the city attorney, Jim Haney, and then Trish Heinonen and myself will be the last speakers. Trish and I have a two-part presentation. The first part is relevant to both commissions. The second part is more relevant to the Development Commission, but Planning Policy may be interested in hearing about that and are certainly welcome to stay. Just gonna take this. Perfect.
All right. Well, I'll remind you that you're in a room that is mic'd, so I will do my best to speak up. If you can't hear me, though, please let me know, and I'll use a larger voice. I was planning on standing up, but since we might have some of our panel interjecting, I'm just going to stay seated for now. I want to thank you for coming this evening. This training is important, and the service that you do and your volunteer commitment to the community is much appreciated. We have, 15 active boards and commissions. That means we have over 125 volunteers, and these are appointed seats. So again, thank you for your service. For those that don't know me, I'm Tina Eggers. I'm your city clerk. I've worked with Issaquah for 15, but I've worked with local government for over 25. I'm charged with the legislative work of the council, and our office does records administration. We also coordinate the many events and recruitment with boards and commissions. And one of our tasks is to provide your mandated training. So that's why we're here. To my right, or as you can see from your left, we've got Jim Haney, our city attorney, and then Tisha Gieser, again, she's the deputy city clerk. So we're split up our presentations so that we can try not to be too boring. There's some excitement there. But let's go ahead and get started. All right. So the intent of the open government training is to increase your knowledge of the laws and responsibilities that jurisdictions have who perform these duties. That is specific to staff, for our council members, and to our appointed officials. The state auditor's office is looking for ways to reduce findings, decrease violations, and cities are certainly looking to reduce risk. The state auditor's office found most violations were not malicious or intentional. Violations resulted from insufficient knowledge or training, which is why my fourth bullet is important, because it's really to eliminate inadvertent violations. And the more you know, the more that you can help each other stay within the right zones of public records and OPMA. The Act is intended to foster open government education and, again, to reduce liability. Thank you. So the Public Records Act, we're going to look at that one first. It's not new. It's been around since 1972. It's also referred to as the Sunshine Law or the Sunshine Act because it was created by the people of the state to foster open and transparent government. It requires that all public records maintained by the state or local agencies are made available to all members of the public. There's very few exemptions, and those are in our state statutes that would list those few exemptions. This does not just mean the written or physical records that the agency has. This could be electronic, it could be text messages, it could be photos, videos, emails, handwritten notes. As your city clerk, I'm designated as the public records officer, and that just means that if someone wishes to file a formal request, they would do that through my office. As your city clerk, I also manage the city's email system. All the emails come in and are retained and what's the word? They're retained and captured and retained. So if we had a request for something specific, we could do some queries and locate that information. City staff who prepare your agendas and minutes and staff reports manage the records that they're responsible for. Should a request come in for records that, and they're asking for specific records that are beyond the ones that we maintain, we may contact you and say, here's what is being asked for, here's the parameters by which we need you to search your personal records for, and then you would have a responsibility to maintain those records, not destroy them, work with our office to produce them so that we, the city responsible agents, could then determine if they are responsive and if any exemption applies. So it's not decisions that you would make on your own, it's ones that we make internally. With that, I would remind you that, again, if you're instructed, you have an obligation, a legal obligation to search and not destroy and to produce those records, and we would work with you to transfer those over. Saying that, though, you are allowed under the state to capture notes, meeting notes that serve to your benefit. You can also discard those records as they have met your needs. It's when a request for records has initiated that you would have to not have discarded them. So feel free to take your notes, discard them as they have served a purpose to you. I would recommend that you find a rhythm that works for you. So if it's after a meeting and you want to leave your note-taking behind, staff can recycle those. If it's something that you want to do monthly or quarterly, that might be a good idea. Some commission members will obtain a separate email account so that it's not blended with their home stuff, or they'll have a separate file folder for it. And it's just sort of managing the records that you have, so if and when you were asked to produce something, that it'd be easier when you came to that situation.
Tina, if people have questions, should they interrupt you, or would you like them to hold them till the end?
If you have a question along the way, we'll do our best to answer it. We may indicate that we'll have more on that topic at a later part of the presentation. So if there's clarity that you need, let me know. And if we hear that there's an area of topic that requires more information, we can certainly facilitate gathering that information and distributing it to you at a later time. All right. The second part of the Open Government Training Act is OPMA. It's also, the long phrase of it is Open Public Meetings Act. This is not new either. This was created in 1971. It's housed under RCW 4230, and it's scattered throughout our municipal code and specifically with the creation of our boards and commissions. We have a varying level of boards and commissions, so we have some, like our sister cities, that has less responsibilities than, say, planning or development commission. So yours is already a higher level under the state and definitely falls under OPMA provisions. It basically means that your meetings are open from start to finish, or sometimes referred to as gavel to gavel, if you were in the council chambers. There's very few exceptions where you could have closed sessions. Those are considered executive sessions. I'll touch on those in a bit. Typically, our other boards and commissions wouldn't see executive sessions, but I know that you've had some certain situations where you've been where you've experienced those. So I'll talk about those in a moment. Let's talk about your regular meetings versus your special meetings. So your regular meetings are your date and time, location specific. It's your regular meeting calendar schedule. So it's my understanding that Development Commission meets the first and third Wednesday of each month, 7 p.m. council chambers. And then Planning Policy Commission meets the second and fourth Thursday of each month at 7 or 6:30? 6:30. And that would be in the council chambers. Any time that you would hold a meeting outside of this scheduled date, time, or location, it'd be considered a special meeting. And we would want to ensure that the noticing indicated that your agendas indicated that, your minutes, and that you would want to be cautious at those special meetings to not take any final action on a topic that wasn't explicitly identified on your agenda. So you'll notice that your agendas indicate, decisions or information, little footnotes on action. So we look out for you in that way. Yep.
Is there a time frame in which notification of special meetings has to be made public?
Yes. So if you click to the next screen here, special meetings can be also referred to as other things like this joint meeting, training, a workshop, retreats, tours. Regardless whether it's a special meeting or a regular meeting, we must have it noticed at a minimum of 24 hours before the meeting. We prefer more noticing than that, so we strive to get that out at least 5 days in advance so that you have the materials that you need to be prepared for your work session.
And if it's a public hearing, if it's the first night of a public hearing, then it's a different set of noticing requirements.
Right. There may be other elements involved that require staff to have done major advanced noticing. Yep.
Can I ask a question? What is not a meeting? For example, if a subset of this group got together to discuss some particular matter on some evening, but without any formal authority, but is that a meeting?
Well, it depends. So if it's a quorum, and you're discussing business that would have come before or is intended to be the commission's work, then that meeting would need to be noticed. If you are less than a quorum, or you're working in a committee form, again, less than a quorum, you can go off and research or review something and bring it back to the full commission for review and action. You've got some quasi-judicial matters, though, that would have some restrictions, and the attorney's going to talk about that later. Do you guys meet in subcommittees at all?
We haven't for a long time.
Okay.
And if you're meeting for a purpose, if you're getting together for a purpose that isn't related to business of the board, as many of you as want to get together can get together. If you're having a barbecue, someone's having a barbecue and you go, or you're attending some campaign event that you happen to be at together, that's not a meeting, even though you happen to be there. A meeting really occurs when you're discussing the business of the commission, when you are transacting the commission's business. So anytime a quorum of the commission gets together and is discussing or transacting the commission's business, that is going to be a meeting.
Right. So a quorum for either of your commissions would be 4 members would constitute that. As the attorney said, you're allowed to travel and gather together so long as you are not taking testimony or deliberating or discussing, considering, reviewing, evaluating, and or taking final action on something that would be commission business. I skipped ahead a few slides. I'm going to go back, but I thought it was important that, since we were discussing it, you also want to be mindful that you're not violating OPMA through other avenues. So if 2 of you were discussing commission business and then one person sent an email to 2 others or made a phone call and you've reached that 4-member quorum, even if it's in a string element, you violated OPMA. It's really about saving your discussion for the noticed meeting, because the public has a right to be present and observe what you're doing.
Quick question.
Yeah, so we don't have a concern about giving the appearance of a meeting if we happen to be meeting socially or something. I thought that was not appropriate.
Well, my advice to counsel, and they're a higher level authority, but it's always good to know appearance can, maybe don't group in groups larger than 3. Ensure that you're refraining from talking about, the commission's work, but you are allowed to say have a potluck so long as you're well behaved.
I think the thing to remember in something like that is those kinds of situations are real easy to turn into meetings.
Right.
You know, you're meeting socially, and then someone says, well, what do you think about this issue? And all of a sudden, you're starting to discuss it, and it becomes a meeting. So it's real easy for that to turn into a meeting, and that's why we always urge caution about that. But technically, it is not a meeting unless you are transacting the business of the commission. Unless you are discussing the business of the commission, it's not a meeting, no matter how many of you get together. And you can get together for social purposes and other purposes that are not within the scope of the business of the commission.
So just for clarification, 2 members from PPC, 2 members from Development Commission, and 2 city council members got together and we had coffee and we were talking about business. That would constitute a forum? We're 3 different bodies.
No, it has to be a quorum of the particular body, and I'm sorry to jump in, Tina,
No,
but it has to be a
yep.
quorum of each body, or any body of those that has a quorum present is holding a meeting.
Got it. Okay, thank you.
So I'm going back 2 slides now, just so I can touch on the closed portions. There would be very few exceptions to having an executive session. Council generally does these. It's dictated in RCW 4230 110, and there's, again, very specific reasons. It might be litigation, could be property acquisitions or things like that. It's discussion only. Final action would need to occur in open session. And again, exemptions are very few that would allow you to go into a closed meeting. The attorney or legal counsel or staff would guide you through that if and when it was needed. I'm going to go to the next slide. I've got one more on executive sessions. And before you were able to convene the executive session, state law requires that the presiding officer state the specific RCW and the amount of time. And again, it's something that we would help you through if and when there was a purpose or a reason for that.
And just a comment that one of the things to keep in mind about the Open Meetings Act and the Public Records Act both are that there's specific language in the statutes that say they are to be liberally construed in favor of disclosure and in favor of open meetings, and every exemption is to be very narrowly construed. So every time you see a court case, and I read a lot of them on the Open Meetings Act and the Public Records Act, that's the first thing out of the court's mouth when in the opinion. It's always, we construe the act liberally in favor of disclosure, we construe all exemptions narrowly. And so if you think, well, it's kind of within the spirit, or, you know, I'm not quite sure, always err on the side of caution, because the court will construe it as being an open meeting unless it's very specifically exempt.
And one thing I would just add is, along with email, be very conscious of texting. That is one where the serial meeting, where 2 people talk and then one of them takes that and adds it to another, and now you've created a serial meeting. And we try and remind you in email, but we're often not on your text chains. So.
Not only remember that for open public meetings, but as Tina would tell you, remember it for public records, because your texts on city business are public records. And if we get a public records request for your texts, we are going to have to produce those to the extent we can. And so just keep in mind, I always tell people that if you question it at all, something you want to say, and whether you'd like to see it on the front page of the local newspaper, pick up the phone and call and say it instead. That way you're not making a record. But if you're going to text or you're going to email, potentially anything is going to be disclosable, regardless of how embarrassing you may think it is. So just urge caution in the communications that you do use.
Right. I would, from the clerk's office, say the best thing you could say is that you don't text to communicate any commission conversations. That way your affidavit could be that statement. We're going to go ahead and move on to, yes. So If you knowingly, intentionally violate an OPMA, there are some individual civil penalties. And those penalties are stated, or dollar threshold is set by the state. It says for the first penalty, it's $500, and for each additional, it would be $1,000. The city has its own liabilities through the court cases or costs and attorney's costs. And ultimately, the action, if it was found to be an inadvertent violation and we lost in court, the action of the body would be considered null and void. And I can't imagine how you would go about undoing something that's in place.
And just to emphasize on that when Tina says individual liability, the statute says it is individual liability. That comes out of your pocket, not the city's pocket, if you're knowingly violate the OPMA. The city does have an ordinance that indemnifies all local officials and all staff for anything that is not covered by insurance. These kinds of things aren't covered by insurance, OPMA violations, but it indemnifies you if you were acting in good faith. It would not indemnify you if you were knowingly violating the Open Meetings Act. So just keep in mind that, because it has happened in other jurisdictions that I have worked with where individual commission members or council members were sued individually to get their records and for knowingly violating the OPMA, and the city did not. There was a real question in those cases as to whether or not the city would indemnify them and whether they were acting in good faith. So.
Right, and that's why training is important and having conversations where we're all together, because there's going to be moments where you're, having a conversation, and this is when you need to be mindful so that you are not inadvertently violating OPMA.
And feel free to contact us if you have any questions.
Well, and that's the other point, is that staff can send out inquiries to the group and collect that feedback. We wouldn't want an individual commission member doing that to their full group. So if it's data collection, let staff do that. That's their job. They are able to do that. Because if you were doing it and it reached a quorum, you've just had discussion of business of your commission, and that would be a violation. So rely on your staff. Okay. Tisha's going to take over the effective meetings portion.
Hi, everyone. I'm Tisha, as Tina mentioned. Thank you for being here this evening with us. I'm going to talk to you for a few minutes about effective meetings. We're going to talk fairly generally about some provisions in Robert's rules and just some things to keep in mind during the conduct of your meetings. So we'll be covering specifically your role as members, some general meeting procedures, some tenets of debate, and voting.
You're going to have to give me a high sign to know to go
sure.
forward.
Got
You
it.
ready for the next one?
Okay, sounds good. Okay, ready. All right, so as far as your role, so there are a number of factors that contribute to efficient meetings, effective and efficient meetings. And a number of these occur prior to the meeting even beginning, including having an agenda set, which is set by the staff liaison in consultation with the commission chair, having rules and regulations that dictate how specific procedures are handled by the commission. And another aspect that contributes to effective meetings is some of your responsibilities as members. One of those being attendance. So a meeting can't occur if there is not a quorum of the commission present. You've heard the quorum talked about a few times by now, so I think you're all clear that a quorum of a commission of 7 is 4. This means that we really need you to communicate any known attendance conflicts in advance. This is particularly important for both of your commissions because a lot of the work that you're doing is time sensitive, and as Lucy and Tina mentioned, there are often some stringent legal noticing requirements that have to occur, and there's a cost associated with those notices in the newspaper, sometimes physical postings as well. So again, we just ask that you communicate known attendance conflicts in advance to your staff liaison or city staff. And we'll talk in a minute about distinguishing your absence from meetings as excused or unexcused. Then also coming prepared, reading through the agenda materials that staff have prepared for you. I know they can be significant in size. And then also come willing to participate in discussion and of course vote. And we'll talk about some exceptions to that in the next few minutes.
And could I add one thing?
Yes.
Please send your questions ahead of time to the staff person, if at all possible. It allows us to be prepared and to be effective in helping you to move forward. So, if you are reading your packet on the weekend and you want to send us an email Saturday night or Monday before either our Wednesday or your Thursday meeting, that is so helpful because it really allows us to prepare a more thoughtful presentation or be prepared to respond.
Question on the quorum. What is that time threshold before, getting the quorum? How long do you have to wait, or are we allowed to typically wait, before enough people show up?
Yeah, you're not, the meeting cannot really be convened until there's a quorum, so I would suggest that you wait a reasonable amount of time, and I guess that can be somewhat flexible, say 15 minutes is decided on. If a quorum isn't reached, there are some procedures to sort of preserve that legal noticing that's occurred. I think actually both of your commissions have done this at times where the individuals present will convene the meeting, and really the only thing they can do is they can adjourn or continue it to a date and time certain, and the staff can post the door. So there is a process there, but we would prefer to avoid that, particularly if individuals are showing up to make comments at the hearing. So, but there isn't a specific time parameter.
But
I'll give you.
let me just add one piece. But that's why RSVPing either to a poll or a meeting invite is so essential, because we don't want everyone showing up if there isn't a quorum. And Tisha's absolutely correct. For instance, the UVDC did, because we were down to such a few number of members. We knew in November that we were not going to have a quorum for a meeting that we had advertised a few days beforehand. So the chair and the vice chair and I met and opened the meeting and delayed it due to a lack of quorum. So no one else showed up but the three of us. But it is really, that way we can have something on the website. We can do things to let people know that it's going to be delayed. So as soon as you can let us know whether you are or are not able to attend, it really is helpful.
And I would even back that up more as, as an appointed official, you have, at least on the known meeting dates, there's an expectation that you're here. We understand that there's, an illness or, travel, or there's some indicator there that would, but these meetings are important. Your involvement's important, and it's very expensive and time-consuming to continue meetings. So we're glad that you have fuller memberships now than you had previous. So
I will also give you a real-life horror story, which is fresh in my memory because it happened to be last night. I was in a meeting or supposed to be a meeting in another jurisdiction, and I won't say which jurisdiction it is, but I arrived ahead of the meeting, probably 10 or 15 minutes ahead of the meeting. At the time the meeting was supposed to commence, there were 2 out of the 7 members who were present. They decided to wait. 10 minutes later, a 3rd member showed up, still not a quorum, and the city clerk tried desperately to call around to all of the other members to try to get them to the meeting. Couldn't reach anybody. They decided to continue to wait, and we sat for 45 minutes until they finally decided that it was enough and they were all going to go home. So I was asked at that time, well, is there anything in law that says how long you have to wait? And I said, no, it's really up to you as to how long you want to wait for a 4th member. But it would have been nice if the 4 members who didn't show up would have let big clerk know in advance that they weren't going to be there, and the meeting could have been canceled. So,
And I'll add one more thing. 3 unexcused absences can result in your being removed from the commission. It doesn't happen very often, but it's part of, we are really depending on you, and if a commissioner, if something happens in your life, please just let us know. And we've had commissioners do that. I've had a baby, I thought I could do this, I can't do this and have my job, I'm going to need to resign. That's wonderful. We know, and we'll be happy to have that commissioner back at another time when their life is more settled. Or, sometimes commissioners move and they're no longer living in the city. I suppose they maybe could continue to serve out that term, but it wouldn't be convenient to them. All perfectly good reasons to just let us know that you're not going to be able to attend. And then we know that we need to be looking at the alternates maybe more regularly and identifying them as regular members. We cannot elevate an alternate to a regular position unless we go through the council, but we can work with the alternates to have them there prepared to serve as regular members.
So getting back to that was a good conversation. Getting back to our meeting procedures. So we've got a quorum present, and what happens next? The meeting is convened, and the chair plays that role. And there are a couple important things for the chair to distinguish at the beginning of the meeting, and that is who is excused. An excused absence would be one that was anticipated to some extent, even if it was last minute for some sort of illness or something unexpected. An unexcused absence would be one that wasn't communicated in advance. And as Lucy mentioned, it is important to distinguish those because there can be some repercussions for continued unexcused absences. Another important thing for the presiding officer to announce at the beginning is if there are regular members absent, which alternate members will be voting in their place. This will prevent awkwardness if and when there are votes to be taken at the meeting, so everyone's clear on who's participating in the vote. Lucy, next slide, please.
Oh, sorry. I already switched.
Thank you. So these here on the screen are some general procedures for your typical agenda items. I was looking at your minutes prior to this meeting and saw that the 2 different commissions do handle commissioner Q&A at different times. Sometimes it's before the public hearing, sometimes after. But this is just designed to put in print what you're probably already familiar with, which is a sort of a typical process for an agenda item. I know many times your items are sort of continued over multiple meetings. In the next few minutes, I'd like to talk to you a bit more about the debate and voting aspects of your agenda items. So as far as debate goes, both of your commissions subscribe to Robert's Rules of Order, and it's a big book. There are a lot of provisions, and they're on any situation you can imagine virtually. So I'm just going to focus on a couple of sort of, again, basic tenets of debate. I think that they're intuitive to most of us, just as far as how to interact with other people, but they're really important for you to be intentional about. For times in your meetings where there could be controversy, it will be handled much more evenly if you're practicing some of these guidelines, even if they may feel a bit formal at times. So one of these key tenets is fairness and equity. You're part of a 7-member commission. You all have equal rights. The chair has, a particular role to facilitate those meetings, but essentially has equal rights. So it's important that you be mindful of a balance there. And again, the chair sort of bears the brunt of that role in facilitating your meetings. So some practices to keep in mind are that you should be seeking recognition of the chair before making comments. I don't know what's particular to your, or typical of your commission meetings. Sometimes that's raising a microphone, maybe raising your hand, making eye contact, so that they know that you would like to be sort of in the queue to speak next. In the spirit of fairness and equity, Robert's rules suggest that every member have the opportunity to make a comment once under debate before anyone makes a comment a second time. And let's see here. I think I've, there isn't a formal rule as far as when the chair should be making their comments. A recommendation is that the chair can wait until the end as things are wrapping up. But again, there's not a hard and fast rule. That's just a guideline here. All right, so let's move on to the next tenet, which is courteousness. So a specific guideline for debate is to not impugn others' motives. Also to address comments through the chair. And I know this can feel formal, particularly for smaller groups, but it's really meant to help diffuse situations. If there is disagreement when you're looking directly in the eye of someone with an opposing viewpoint, there can be this tendency to foster a back and forth sort of conversation, and that's not how your meetings are designed to function. So the comments should be routed through the chair. The eye contact, preferably, should be with the chair and maybe the other members of the group. Not necessarily the audience. The focus of the meeting, again, is with your fellow commissioners. Interruptions are not appropriate except under a few circumstances. One of those might be if it has occurred to you that maybe the chair inadvertently skipped over an agenda item, some sort of procedural issue. Maybe your vote didn't get conveyed correctly by the chair and someone has started talking. That kind of situation would be considered like a point of order, and you would want to interrupt. But really, for any other reason, anything that isn't particularly time sensitive, the practice or the guideline is to wait until you have that recognition and your colleague is done speaking. And then lastly, under this slide, honor the outcomes of the commission. So obviously you're not all going to agree on all points, but again, you've agreed to be on the 7-member commission. So if an outcome is decided on, it might not be the one that you are in favor of, but moving forward, it's important to acknowledge the fact that that was the will of the group. And lastly, efficiency. So as I mentioned, Roberts specifies that individuals should have up to 2 opportunities to comment on each motion before the commission, and they actually additionally specify those comments shouldn't exceed 10 minutes. We're not implying that you need to have a timer at your meetings in that regard or exactly monitor the frequency, but I think it's just a good thing to keep in mind in trying to achieve some balance. Also, just in the spirit of conducting the business of the meeting, you're asked to be concise, to not repeat comments, and to stay on topic, and particularly to be making your comments to the particular motion before you. Next slide. So just a few comments about general meeting conduct. As I mentioned earlier, I know it can sometimes feel unnatural. I know that often you have members of the public attending your meeting. You have prescribed times that they can speak to you under a public hearing, if there's one on your agenda, or during the public comment period. But really, the work of the commission is among the 7 of you at the table, and it is important that the questions and the dialogue and debate stay there. If there's an individual who's trying to interject something from the audience, that's not appropriate, and it would be in line for the chair to indicate that. And if there was a desire of the chair or another member on the commission and there was agreement to bring someone forward to maybe ask a follow-up question or make a clarification, that would be okay. But what you need to keep in mind is that it's important to be consistent with how you treat everyone, which is why we have guidelines as far as an approximate time for those who address you, and clear places on the agenda for that. The last point I'd like to make is regarding voting. Jim is going to talk to you a little bit more about appearance of fairness disclosures, and Tina will be talking to you about ethics and conflicts of interest. But I'm going to speak to you about some of the more practical aspects of that. So when the time comes for a vote, it's important that you've spoken under the disclosures or just stated a conflict of interest prior to the vote. If you have one of those instances, you need to leave the room so as to not be participating in the vote. If you do not have a conflict or an appearance of fairness issue, but you don't want to vote, you may abstain from voting. However, your rules of procedure, as does our city councils, indicate that an abstention is counted as a yes vote. So your vote will be a yes. The chair is not obligated to and shouldn't ask for abstentions. So if your plan is to abstain, you need to state that prior to the vote. And again, it will be recorded as a yes. Using unanimous consent is a tool that you can use at your meetings. You know, that sounds something like, if there's no objection to continuing this public hearing to our next meeting, it is therefore continued. I'm not doing the best job of stating that, but the chair can do this. This can also work for the minutes. Are there any objections to approval of the minutes of our past meeting? Hearing none, the minutes are so approved. That can be used for more procedural things, continuing a public hearing, minutes, anything else where there seems to be broad agreement. If any member isn't in agreement, you need to say something. I object, wait, and then a vote will need to occur. I also just wanted to emphasize to you how important it is that you're clear on what is being decided and voted on. And if you have any uncertainty there, please speak up. If you would like something displayed on the projector, because you're unclear on the wording that your colleague mentioned in a motion, or you're unsure that the consensus that's being reached, that you're in line with that, please. It's really difficult once the meeting moves on to do anything about that. It's very difficult to undo the work, so please feel empowered to make sure that you are clear. And that is what I have. Thank you.
On the guidelines for public discussion and the need to be consistent in that, so if commission normally says they notifies the members of the public attending that we'd like you to keep your comments to 5 minutes or whatever it is. Yeah. If there are only one or two people, fewer people in attendance that have indicated they want to speak, is it all right to be flexible in that regard? Can you change the guidelines from meeting to meeting in terms of how much time members of the public are given?
So the presiding officer, and generally the rules state this, does have some flexibility with the will of the group. I would say, and if anyone else has input, they can share it. I would say that that's maybe a good thing to convey. For example, you have reached the 5-minute comment period because we have so few in the audience tonight. With the will of the group, we will allow you to conclude your remarks or to have an additional 5 minutes, something like that. So kind of recognizing that you are doing something a little different, but I believe that is within your right, or particularly the chair seeking agreement from the group. Does anyone have any opposing perspectives or different?
Well, I've certainly seen that, and of course, I'll now find out I'm wrong, but where, for instance, at one meeting, there's 40 people, and at the next meeting, there are 2 people. At the 40-person meeting, they may say each person gets 3 minutes. At the 2-person meeting, they may not even state a time, but preferably to say you have up to 10 minutes to speak. I think as long as you're consistent within the meeting and that there's an objective basis for identifying a shorter or longer time.
I guess my perspective is that you're trying to, and I'll get into this a little bit in my presentation, but you're trying to get information from the public when the public is testifying. If you're in a legislative hearing, which I'll talk about a little bit, What you're trying to do is get the public's input on some legislative matter that is in front of you. If you're in a quasi-judicial proceeding, what you're trying to do is hear the evidence that the people want to present to you. And sometimes the issues are more complex than others, obviously. And sometimes people will say, gee, I don't know that I can really address all of the issues I want to address in 4 minutes or 3 minutes or whatever it is. And I think you do have to be flexible, particularly in the quasi-judicial context, to give people a reasonable and meaningful opportunity to be heard in front of you. I think most jurisdictions are anywhere from 3 to 5 minutes. That's kind of the standard rule. But I think most jurisdictions also allow some flexibility, as Tisha said, to say, okay, can you finish at the end of the 5 minutes or whatever, say, can you wrap up your comments? And they say, well, I've really got 3 more issues I need to address. Then to say, well, if there's only so many people, we'll allow you to do that, subject to the board overruling the chair. We'll allow you to do that. And, but you can't do that in every situation, because if you have 40 people here and they all want to take 10 minutes, you're never going to get out of here, and you need to be able to do your business. So it's really kind of up to you as to what is a reasonable opportunity.
Does the city have a recommendation as to when in our meetings the public comment period should be? I noticed that some commissions have public comments at the end of the meeting, and some have public comments after the staff and the applicant have made their presentation, and before the commission in question has their discussion, comments, questions, whatever. Is there any recommendation on the city as to which of those 2 general approaches is better?
Well, I think, too, it's important to distinguish that you have sort of 2 types of public comment at some of your meetings. So you have your agenda items, which have a public hearing component, which is specific to that item. And then I've seen that at times you also have a public comment agenda item that's just for general public comments. So those are going to look different as far as when they occur. That public hearing item, that public comment should occur before your decision making. Like I mentioned to you, I did see a difference as far as sometimes commission questions occurring of the staff and applicant occurring before or after. I think, again, consistency is important. Your rules and regulations typically provide a order of business, and so that would be what you would look to follow with your agendas.
I guess what I would say is that it depends on what public comment period it is. Some jurisdictions and some commissions just have a general public comment period. Anyone can get up, talk about anything, any item of commission business in this general comment period. I think the best practice is to do that up front, because at the end, you've already taken your action and it's too late for the public to comment on it. So it's best to do that one up front. If you're doing a public hearing, and there are 2 types of public hearings I'll talk about in my presentation, a legislative public hearing and a quasi-judicial public hearing. In a legislative public hearing, you want to get that public comment during the public hearing. So you don't do it at the beginning, you don't do it at the end, you do it whenever that public hearing occurs. And once the staff, I think, once the staff makes its presentation, and I think Tisha covered that in one of her slides, makes its presentation, then you'll open the public hearing for public comment, and that's when you want to take that, when that matter is at issue. In a quasi-judicial proceeding, and I'll talk about this a little bit as well, that's where you're dealing with a particular development application. And so in a development application, an applicant bears the burden of showing you that the development application meets the code. Therefore, most jurisdictions, and I think this is the proper practice, allow the applicant to go first, and either the applicant or maybe staff to make an overview and then the applicant to go, so that they have the opportunity to show you how they meet their burden of proof. Then after that, then it's for the public or the staff to come back and talk about their presentation. And then in most quasi-judicial proceedings, because again, the applicant has the burden of proof, you usually give them a slot at the end to just respond to things that people have said. So it really depends on what the purpose of your comment period is.
Mel had a question.
Can you review again where we stand on asking people to sign in, name, address, no name, address?
Sign-in lists are optional. It's not required to attend a meeting. You can certainly ask the person to state their name and address or relationship to the city. They can decline or indicate a neighborhood, but you can certainly ask.
Yeah, I think it's difficult to compel them to say, well, we're not going to let you speak unless you give us your address. But I think it's important. There are both upsides and downsides to giving the address at the hearing. The first upside for the individual giving the address is it lets you guys all know what their relationship is to the project. And if somebody lives outside the city, maybe you think, well, I know you take everybody's input into account, but if someone lives outside the city and is not really going to be affected by the ordinance, you might discount that a little bit. So, and vice versa, if they live close to the project or they're really going to be affected by it, that leads you to give them a little bit more credibility. The second upside for them in giving their address is oftentimes we're compiling a list, a mailing list, to give out notices of upcoming hearings and so forth, so that we can maintain the transparency to the public. And if they just don't sign in or won't give their name or anything like that, then we have no way of really contacting them unless we know them. We don't have a way of doing that. So that's an upside for them, is it helps us give them more information. The downside is that sign-in lists are public records. And sometimes people don't want their address to be out there. And so they have to recognize when they sign in or when they give their address that anyone can know their address, anyone can get a copy of that sign-in sheet. So that's why we kind of allow people to say, okay, you don't have to give us your address. For all we know, there's some reason why you don't want people to know where you live. So.
And I'll just say from staff's perspective, the two things that we particularly like are name and email. We're often not mailing things, we're emailing things. But it is helpful for all the reasons that Jim identified. And what I gather is you could testify anonymously if you wanted to.
Yeah, and how much weight you give the testimony of somebody who testifies anonymously is up to you. What weight you give anybody's testimony is up to you. So.
Could you go over again the comments about unanimous consent? I was a little confused.
Sure.
What
yeah.
happens if there's not unanimous consent?
Right.
I guess it's more.
So unanimous consent is just a tool to kind of help the meeting, help you move through an aspect of the meeting quicker if there's clear agreement among all members. So if there is not clear agreement, or if maybe the chair thinks there is and says, is there any objection to, you need to say, yes, I object, in which case a vote will occur, a standard vote.
If it was appropriate for a motion at that time. It helps for the majority of the regular members to decide how they're going to move forward. So do they indeed continue the hearing, or do they close the hearing?
But it's not on a motion.
You could first start off with if there's no objection, we will do this. If there's an objection, then you can go down the path of saying, would someone like to call for a motion? And then see what the majority of your members wish to do with it.
But I mean, if you're making a motion for a decision on a permit or...
You would want that to be a formal motion.
Right.
But there's those minor things. You could do this for minutes, you could do it for, things just like, do we have consensus to move forward?
So a real life opportunity may be, are there any objections to approving the minutes?
Right.
Hearing none, the minutes are approved. Yes.
Of course, the other way that it's done by jurisdictions is a consent agenda itself, where if you know things are going to be non-controversial coming into the meeting, maybe the chair works with the staff and puts together an agenda that has consent items on it that says approval of minutes and so forth, and those consent items may be passed in a single motion without taking them up individually. That's certainly the way the council does it, so it's another option.
Right. If that was a path that was of interest to the board or commission, we would want to work with you on establishing that rule or guideline within your rules and regs, your bylaws.
Regarding voting, my understanding is alt members do not get a vote. Is that correct? And if they fill for a regular position, do they get a vote then? Is that how that works? Okay.
So, code of ethics. I only have 2 slides on this. Behind your PowerPoint is our code of ethics policy, and then a little guideline document, little Q&A. You should have signed off on this document, being a board and commission member. Once you have, it's on file with my office. New members should have received an email once or twice from me saying, sign your ethics form, and provided you a link. If you're like, that doesn't ring a bell, you can go to, if you move forward, you can go to issaquah.gov/ethics, and it'll bring you right to that electronic page to sign off on it. What you see on the screen here are the categories by which are spelled out in the actual policy. And I won't read through, I'm not going to read you the document, but I will say that, let me find it here. Let's see. Like conflicts of interest section prohibits items such as using city property or money for personal gain, disclosing confidential information, having an interest directly or indirectly in city service contract or sale. There are some exceptions to that are allowed under state law, so as long as that was not a conflict. Gifts and gratuities section prohibits giving or receiving special privilege, exemptions, gifts, and items of value. There are some exceptions, such as, yes, you can have a meal that relates to a city business or event so long as the value is under $50. You can accept awards of recognition for public service. Political activity, as Jim mentioned earlier, you can go do that on your own time, but when you just can't use city resources and facilities for that, so that you need to be mindful of that. We've got some more issues spelled out in the actual document that's attached. And then public records in the open public meetings section basically reiterates that you are bound by this act and you are bound by the same in the OPMA. The remaining portion of the ethics form, thank you, deals with the whistleblower protection and then who to seek out if you have clarifications or if you want to interpret a portion of the policy. You can do that through the HR department or through the city clerk's office. And then the city has a role in investigating complaints, and there is a section as to if there were violations, that there could be civil penalties that we talked about earlier, and someone could certainly lose their office or be suspended from service. That concludes that section.
Okay. First of all, thanks for being here and thanks for having me. It's always nice to see how many people are willing to volunteer their time to work for their community. So congratulations to all of you on being appointed, and condolences to you and your family for all of the time you spend. I'll just introduce myself. I'm Jim Haney. I'm the city attorney. I have been practicing for the last almost 40 years. Started in 1980, and I have been limiting my practice to working with municipal clients since 1983. So that's pretty much all my practice is representing municipal clients. I started with the city of Issaquah as a prosecutor, as the city prosecutor in 1983. And I prosecuted cases for the city for several years. And then I moved up, I guess you'd say moved up, into doing assistant city attorney and civil work for the city, and became city attorney for other cities through my law firm. And when Wayne Tanaka retired in the end of 2015 or 16, I took over as the city attorney here. So I've been acting as the Issaquah city attorney for that period of time. I want to start by talking about two types of public hearings. There are two types, as I mentioned before. There are legislative public hearings, in which the object is to obtain input from the public on a legislative policy matter. An example of that would be the comprehensive plan. That's a legislative matter. Development regulations that may come before you, various sub-area plans like the Central Issaquah Plan, and area-wide rezones where you're looking at large areas and rezoning multiple properties. Those are considered legislative in nature. So when you're acting in a legislative hearing, your object is to get input from the public on that legislative policy decision that you are going to make. The contrast with that is quasi-judicial hearings, and as the name makes it sound like, you're acting as a quasi-judge in those proceedings. Your object is to decide the legal rights of parties in the proceeding. Examples of that are when you're when you're holding a public hearing or on a development application, a specific application. A site-specific rezone is considered quasi-judicial. A preliminary plat is considered quasi-judicial. Now, in Issaquah, a lot of those things go to the hearing examiner. They don't come to your commissions. But occasionally, you do get a quasi-judicial matter that comes to you. And in those matters, your object is to decide the legal rights of the parties involved based on the evidence that you receive.
Could you define the word quasi in this context?
Well, I think you'd say judicial is when you are a judge. Quasi-judicial is when you're acting like a judge. So that's why we use that term to describe it, because you're not really judges, but you're acting like a judge, and the same way that a judge acts. And it used to be, I'll tell you, that the law used to be pretty confused, and the court cases about what was the difference between a legislative matter and a quasi-judicial matter. When was a city board or commission acting like a judge and doing something that a judge would normally do, and when were they acting like a legislator and doing something that a legislator would do? And I think it's pretty settled now after the legislature adopted a definition of quasi-judicial, which is in the Appearance of Fairness Doctrine statute, and it basically says whenever you're deciding the rights of individuals in a hearing or other contested case proceeding, you are acting quasi-judicially, like a judge. So in legislative hearings, again, you're acting like a legislator. You're making decisions that affect the community as a whole. In order to hold a legislative public hearing, we are required to give notice. And notice is generally supposed to be reasonable. It's supposed to give a reasonable opportunity and meaningful opportunity for people to be heard. And that means a couple of things. One, the notice has to be given far enough in advance of the hearing for people to know that the hearing is coming up. 10 days is generally considered to be the minimum amount of notice that you should give for a public hearing in order to apprise the public, and that is what most of the Issaquah public hearings legislatively require, is a 10-day public hearing notice. Notice must also be specific enough to tell individuals who read it what it is that you're going to consider. It's not sufficient to say that we're giving notice that we're considering amendments to the Issaquah zoning code in Title 18, because that doesn't really tell anybody what you're really doing. It kind of narrows the field, but it doesn't really tell the nature of what you're doing. And if I was a person reading that notice, I'd be asking, do I need to show up or do I not? What exactly are they talking about? So notice is generally considered sufficient if it describes the action that you are considering with enough specificity for an individual to be able to make a meaningful comment, to know what it is that you're talking about. And I know I work with staff a lot on notices, and we talk a lot about exactly how specific do we want to be. And there's always this tension between being so specific that the commission may not be able to discuss everything it wants to discuss, and being specific enough to let the public know. So notice is one thing that gets litigated a lot in growth board cases and in other cases that I've been involved in as to whether the public had reasonable notice of what the commission was considering doing. And notice is generally given in a couple of different ways. When we give notice for legislative public hearings, we are usually publishing the notice in the newspaper. Some jurisdictions also require that even for legislative matters that there be posting. Also for legislative matters, some jurisdictions require that we try to give notice to property owners. But those kinds of mailed notice to property owners, published in the newspaper, those are usually related to quasi-judicial hearings that I'll talk about. We do, as Lucy said, use email addresses for people to make sure we comply with the requirements of the Growth Management Act regarding notice, because it says that when you're giving notice to the public, you should use means which are reasonably, which you can reasonably expect would apprise the public of a hearing coming up, and you should make an effort to notify those who are known to be interested in the proposal. And when people come up and testify and they give us their email, we know that they're interested, so we do provide them with notice. They also give us that express that interest through their comments. We get an email and so forth. But that's why that is important, is to try to give that required notice. With respect to the opportunity to be heard, at a legislative public hearing, all members of the public should be allowed to speak. It's really kind of an informal process. It's not as formal as quasi-judicial processes. If you think of the way a courtroom operates, witnesses are called, they testify because the lawyers ask them questions, and then when they're finished testifying, they leave the stand and so forth, and they're cross-examined and all of that kind of thing. That's not required in a legislative public hearing, and most places do not allow any questioning by anybody other than the commission during a legislative public hearing. It's really an opportunity for the public to give you their input, and their input is valuable to you on the policy choices that you are going to make. You can establish reasonable rules for the public. A time limit is one of them. If you have a lot of people, you make a shorter time limit. If you have fewer people, you can make a longer time limit. But you really want to gauge your time limit to how complex the issues are. And that's why I always suggest that if you're going to set a time limit, that you always enable the chair with the commission's help to be able to override that and give additional time if that is necessary. You can, in public hearings, legislative public hearings, hold people to relevant things. If someone got up and started talking about something that was completely not the proposal before you, you could stop them and say that's really not germane. It happens sometimes. People just want to talk. They show up, they want to talk about a particular issue, and it may not be what this hearing is about. So I always recommend that at the outset of the hearing that the chair go over the ground rules for the hearing so that the public knows what they need to do. It's always nice to have them printed on the agenda as well, which the City Council does with theirs. I'm not sure whether your agendas include those, but the City Council does have its public speaking procedures. They also do put them up on the screen when the public gets up to testify, saying, here's how you give input and so forth. So I think that's good so that people understand the ground rules when you do that. Next slide, please. So in legislative hearings, once the hearing is completed, you close the public hearing. And that means that the hearing is closed and the time for the public to give you their input is over, unless you have in some way allowed for additional public comment. And a lot of times in legislative matters, people continue to receive public comment in writing at least, or during public comment, the general public comment period. And that's okay, because in a legislative matter, you're making a legislative policy decision. You're not limited to any particular evidence that is before you, unlike a quasi-judicial hearing. You can basically take input at any time and from anyone. The practical difficulty is, and I've run into this in other jurisdictions, where people continue to give their input all the way up to the final day of the final vote on something from you. You've had discussions, and every comment period they're coming and they're giving their input. And when they do that on that final day, it's hard to take that input into account, because at that point you're sitting there, you're having discussed it, you've got something formulated before you ready to adopt, and here comes someone in who now is wondering why their public input isn't incorporated into that document. So, but it is difficult to cut the public off on a legislative matter, and so you just deal with that. It rarely is something that you really need to stop and say, wait a minute, we're going to postpone. As far as the criteria for making your legislative decision, the Issaquah Municipal Code does set out criteria for comprehensive plan amendments. It does set out criteria for development regulation approvals. In fact, all of the various levels of review in the Issaquah zoning code all have separate criteria for you to consider and make your decisions on. Your staff report will always tell you how the staff believes that those criteria have been met, but you're always free, based upon the evidence and the testimony and anything else that is brought to mind during a legislative matter, you're always free to not adopt the staff's recommendation or to change a finding that the staff is stating you should make, or whatever. You're the ones who are in charge of this, and staff is providing you a resource by providing you a draft decision based on what they understand the discussion to have been and based upon what their recommendation is. As I said, you're not limited to considering testimony and documents presented in the hearing. This is different from a quasi-judicial matter. Again, you're not acting as a judge, you're acting as a legislator, and as you know, the legislature takes input from any and all sources up until the time they make things, and then they make a policy judgment. So that's really the same kind of thing here. Next slide, please. So in quasi-judicial decisions, like I said, you're acting like a court. And if you think of how a court acts, what does a judge do? A judge holds a trial to hear evidence and get all of the evidence to decide the case. The judge then makes findings specifically based on that evidence, and only based on that evidence. What evidence did the parties present to me so that I can make a decision? The judge then draws conclusions from that evidence, and ultimately the judge enters a judgment in the litigation, which decides the rights of the parties. And what you do is very similar. You're holding a hearing on the quasi-judicial matter in order to get evidence, so that you can make a decision as to whether a permit meets the criteria or it doesn't meet the criteria. You're going to make your findings based on that evidence. You can't go outside that evidence. You can't say, well, I didn't hear this during the hearing, but I happen to know that that project has this thing about it, or I happen to have heard from somebody else that there's this particular feature on the land. You need to confine, in a quasi-judicial matter, your decision to the evidence that you have received in the hearing. You apply the criteria to the facts in order to draw your conclusions as to whether or not the permit meets the criteria for approval. And by doing that, you grant or recommend approval of that permit, which then decides the rights of the permit applicant. It decides the rights of everybody who testified for or against. And basically, you're making a decision that is like a court's judgment. So when you asked earlier to define quasi-judicial, that's really why the courts look at it this way, is you're doing everything that a judge would do. And when you do what a judge does, you're not a judge, but we're going to say you're like a judge, a quasi-judge. So that's how that works. Next slide, please. As far as quasi-judicial decision-making, I'm an advocate for having standing rules of procedure, but if you do this only rarely, sometimes people don't have rules of procedure and they have to come up with them when a rare a quasi-judicial matter comes in front of them. The hearing examiner obviously has good rules of procedure because he decides quasi-judicial matters all the time. But you get them rarely, so you may not always have those, and it's always a good idea to work those out in advance, to figure them out, how you're going to handle the hearing, and to announce that procedure prior to the hearing taking place so everybody has a fair opportunity to comply with those procedures. Typically, as I said earlier, the party with the burden of proof presents first, other parties go after, and then the party with the burden of proof gets a chance for rebuttal. If this is just an application that is pending before you, then the party with the burden of proof is going to be the applicant. The applicant bears the burden of showing that their application meets the requirements of the code. If it's an appeal of a decision made by staff, then whoever appealed the staff decision is going to have the burden of proof. So it will vary from case to case, but this is generally how we always see it done, is the party with burden of proof presents first, the other parties after, and then the party with the burden of proof gets a chance for rebuttal. It's kind of like what you see in a courtroom. Again, in a courtroom, the plaintiff, or the prosecutor, has the burden of proof. So they always go first and put on their case. Then the defendant comes in and puts on their case, and then the plaintiff or the prosecutor, if it's a criminal case, gets a chance to come back and offer some rebuttal, again, because they have that burden, that heavy burden of proving the case before you. Commissioners can ask questions at any time, and you should ask your questions. It's really up to you as to whether you want to wait until someone has finished testifying and then ask the questions at the end, or whether you want to ask the questions as they go along. But you have the right to ask questions in a quasi-judicial proceeding. You have the right to ask questions in a legislative hearing. So you shouldn't be afraid to do that. You need to get whatever you need to get in order to make your decision. Now, next. One of the things that sets quasi-judicial decisions apart from legislative decisions is that with quasi-judicial decisions, you're bound by something called the appearance of fairness. And you hear about it all the time. You hear that term all the time, appearance of fairness, but it's both a well-known concept and it's sometimes kind of hard to understand. But here's the basics, is that judges and commissioners, when they act in a quasi-judicial matter, are bound not only to be fair in fact, to fairly judge the quasi-judicial matter in front of them, but they must appear to be fair. That is, they must be above reproach in terms of their background and so forth that might cause a person to think that they're not fair. As a matter of fact, the question in appearance of fairness that is asked is whether a reasonable person, knowing all there is to know about your connections with the application or the parties, a reasonable person who is disinterested in the proceedings themselves would be concerned that you might not be fair. It's not that you haven't been fair. We can look at the proceedings, and objectively, when we look at the transcript, we can say, gee, there's nothing here that says that you were unfair. But not only do you have to be fair in fact, you have to appear to be fair. And what that means is that we need to know at the outset of a quasi-judicial hearing what connections you have to the project and to the applicant and to the property, so that we can determine whether you might have an appearance of fairness problem. And I know Lucy does a really good job at these hearings of prompting you with the questions and so forth if you need that, and asking you the things you need to know. And the intent is to get all of those things on the record. And that is important for a couple of reasons. One, because it gives members of the public and those who have the burden of coming before you, have them know about particular issues that you may have and have the ability to respond to that. And second, it's important because if they want to challenge you and your ability to be fair, they need to do it at the outset of the hearing, so they need to know at the outset all of the things about you that could trigger that appearance of fairness issue. And if they challenge you, and if there is a valid appearance of fairness concern about you, you will be required to step down, and you will be required not to participate in the proceedings. And if you don't, and they appeal, or if you don't disclose and they later find out about something that would have been a valid grounds to challenge you, and they appeal, the decision can get overturned and everybody's back here doing it all over again. So we don't want to do that.
So I'll just give you an example. It's only happened once that I've seen where someone had a valid, and we were reviewing Swedish Hospital up in Issaquah Highlands, and sitting on the commission was the head of the emergency room for Swedish. And we asked him to recuse himself, and he agreed. He did show up, and then we had to ask him to leave, because I just want to point that out, that if you are not supposed to influence it, you may not be in the room. And so he left, and everything was fine, and there was no bad intention, but again, it's the appearance of fairness, and even having him in the room with the relationship that he had with the other commissioners, it was a concern that it might not appear fair.
I'll tell you a story from early in my career. I was the city attorney for the city of Black Diamond, and I was the prosecutor as well, and we had a judge who was not a lawyer. At the time, you could do that in small municipal courts. We had the judge who was not a lawyer, and the judge, we would hold night court, and the judge would decide the cases. And if he ever got stuck, he would look out into the audience, and his wife was sitting in the audience, and she would give him the subtle signal as to which way to go in the case. And he would rule the way that she gave him the subtle signal. Well, that's why we ask people to leave the room, so that they can't give the subtle signal. There's no nodding. There's no thumbs up, thumbs down. There's no. I shouldn't use it, but I will. There's no sitting there like in the movie Animal House where you sit there and go, bullshit. There's none of that. So we want to make sure that when there is an appearance of fairness issue, that's why you're asked to leave the room, so that there is absolutely no question that you're trying to influence the body. Yes?
Are we as individual commissioners allowed to, for example, look at a site, an application, or the subject of a for the Planning Policy Commission plat or something like that in advance of the meeting, or are we limited only to what is presented by the staff, the applicant, public comment in the hearing?
In legislative matters, there's no question you're allowed to go look at the site. If there's you're rezoning an area or something where it would be legislative. In quasi-judicial matters, I think you can do that, but you need to be careful about it. And you really should have a kind of a rule that says this. Again, we'll analogize to what a judge and a jury does. When a jury goes out to look at a site during a trial, they are instructed that their view of the site is not evidence, but they're being afforded an opportunity to look at the site so that they can understand the evidence that they are receiving better. So I know that, for example, you get plat maps and so forth, and it's a nice flat drawing on a piece of paper, or a site map, it's a nice flat drawing, and you're kind of looking at it, and you're not really, unless you read these plans all the time, and I know you do, it's hard sometimes to visualize it. And as long as you recognize that when you go out and visualize or go out and actually see the site, it's to help you understand that document better and to understand what that document's showing, and not evidence in and of itself, then you'll be fine. I would say I had a quasi-judicial hearing once with a city council that wanted to take a site visit, and we ended up recording the site visit and taking the council out on site. And it was amazing to see council members like pointing to what appeared to me to be a puddle of water and believing that was a wetland and things like that, and drawing conclusions from it. But really, and so I had to bring it around when we got back and say, really, this is not evidence. You're going and viewing the site. What you're viewing the site for is to help you understand the evidence that you're getting in the proceeding. And I hope that's clear, but that's the distinction.
So a couple of questions. If someone has visited the site, should they disclose that?
Yes, I think you should, and particularly if you have questions about anything that you saw at the site. If you say, I was out there just trying to understand, am I right that, this place up here is where I saw the detention pond, and this over here. If you have questions, it's helpful to bring those to the fore. But again, you should not draw conclusions based on what you see out there, because it's really not evidence.
Is it okay to ask questions as a follow-up? For instance, I have the exact same example in mind. They see a puddle and they think it's a wetland. Is it okay to say, has the property been evaluated for critical areas?
Yes.
But
Because I
not
think
to
that's part of
say
the
this
criteria.
is a critical area.
Yeah, I think to say I observed some areas, when I was out there, I just saw some areas that looked wet. Has it been evaluated for critical areas? And if the answer is yes, it's been evaluated, here's the evaluation. The evidence you rely on is that evaluation and what's been presented, and not what you saw out at the field. It's only there to help you understand and contextualize what information you're getting. Yes.
Jim and Lucy, what's the protocol when it comes to fairness, and say you've not attended the first meeting series? Do we just simply state that fact at the beginning of the meeting, and then if we're asked to sit off for the remainder of the meeting, then we just comply with that, or what's the correct approach to that?
I think it depends. If it's a quasi-judicial, if it's a legislative hearing, there's no problem with that, because again, you're getting the public input. You probably have read the minutes, and so forth, and you know enough. If it's a quasi-judicial matter, then before you can participate in the decision-making, you would want to have reviewed the entire record and have heard the entire record. So if you come in and, this is the second meeting on some quasi-judicial matter, you say, you make it known, I was not here at the first meeting, so I'll stay here and listen to the testimony. If the decision is going to be made tonight, then I won't participate because I haven't read the record. Or if you've gone back and Everything's
Watch
on
the
videotape.
videotape.
Watch the video. If you've gone back and watched the video, you say, I wasn't here at the last meeting, but I have gone back and watched the video, and I have looked at the document, so I feel like I can proceed. You would be fine to do that at that point. It would be only if you hadn't watched the video and you were only here for half of the hearing and the commission's ready to make a decision, then really you shouldn't participate because you don't have all of the evidence.
And when do we state that after the chair has made the introduction or the meeting's begun, or when in that process?
Yeah,
do
I would at the outset of when the matter comes up before the commission, I would suggest you make that statement.
To me, this is a technicality, but under the rules for a quorum, if you have 4 members, but only 3 of the members have seen the whole record, you've got a 4th one that's not prepared, the commission shouldn't act then, I would guess.
That's correct. I mean, at that point, if you don't, I mean, technically you have a quorum, but I think if 3 members were all in agreement, it would be a valid decision, but in many cases. But I would suggest that at that point, if you don't have enough people to be able to put forth all the votes that are necessary to take the action, that you would probably want to continue it until you do have those folks, until more people are going to be there. Okay, so we've listed some of the appearance of fairness questions. These may be familiar to you since you may have been through this with Lucy before, but if not, I'll just lay them out. Some of the questions we like to ask during the appearance of fairness, and I'll just say in terms of the way kind of I like to go about it, and everybody has their different style, but the way I like to go about it is to either have the chair ask the questions, or if the chair wishes me or a staff member to ask the questions, get the council or commission members to indicate if they are responding yes to any of the questions, and then ask them to explain. And then at the end, when everybody has made all of their disclosures, that's the point at which the chair or the staff member or me then asks, are there any challenges to any of the council members? And the reason for doing that is because anybody who was there or even not there and who should have known then what all of the basis was for a challenge and doesn't make it, that challenge is deemed waived, and the council members and commission members can continue to participate even if they would have answered one of these questions yes. The appearance of fairness can be waived, so that's why we do that. We make the disclosures, then we try to figure out whether anybody's challenging. So the disclosures. First, does the decision maker have a personal interest, financial or otherwise, in the matter such that he or she stands to gain or lose by the decision? This is the old classic, you can't adjudicate your own case. And so if you do have a financial interest somehow in the proceeding, you should be disclosing that at the outset.
Ask you a question on that? Sorry. Is that the direct financial interest, or can it be broader in the sense that, making up a story here, there's developments proposed clearly going to raise property values in the city of Issaquah. I'm just making up a story here. I live in Issaquah. That would be an indirect benefit. In that, my house value might go up.
Well, it's a good question. So let me just say that it has to be a financial interest that sets you apart from other members of the general public. So if every time the council makes a decision on taxes or whatever, everybody has the same interest. If the council levies taxes, it's going to go up. But that doesn't mean that a council member has a conflict of interest in that, even though their taxes are going to go up. It's a matter of, are you affected in a way that is different from other members of the public, and the public in general? I would say, for example, let's say you had an ownership interest in the property. That's an easy one. Where you were under contract to sell the property to the developer. That's an easy one. Or a little bit more remote, you owned stock in the developer, and your stock would rise or fall. That's a more direct kind of financial interest that you might consider disclosing, and that might create a problem for you.
Can I just ask a question?
Sure.
For a legislative matter,
Yes.
if there was a rezone of property that was owned by commissioners, is that a concern?
Not under state law. Tina, would there be anything in the ethics code that would address that?
Because I have seen a commissioner specifically trying to change their zoning on their property in a larger zoning matter.
Yes.
Yeah, our ethics policy was intended to complement the RCWs, not add additional restrictions.
Well, I think.
And that was not in this jurisdiction, let me just add.
Good. Yeah, I mean, I think in a legislative matter, generally, you are, if it is truly legislative, you are entitled to bring your own prejudices and own interests to the table. And so that would generally not be an issue. Many cities have ethics codes which would require you to recuse yourself under those kinds of situations. And the state conflict of interest statute is pretty minimal. It mostly deals with contracts and your interests in contracts that come before you, and you don't approve contracts, so it really doesn't mostly apply to you. There are some things about like not taking bribes and things like that in the state ethics code, but there's nothing that specifically addresses, I think, something like you're talking about, Lucy.
Okay, thank you.
The second one that I was going to talk about was, will there be prospective employment for the decision maker or his or her family or as a result of the decision? And I know that sounds sounds like an odd question, but it comes from an actual case where, I hate to admit it, an attorney was on a planning commission, acted on a quasi-judicial matter, and then was hired by the developer 2 weeks later. Held appearance of fairness problem. It was prospective employment, and that was considered to be an appearance of fairness violation, even though the actual hiring did not take place until after the matter was done. The court said, look, nobody gets hired like the next day. We understand that people, there's probably were discussions and so forth. That's an appearance of fairness problem. Is there any business competition between the decision maker and any parties at the hearing? So if you own a local business and your competitor is up here asking for a permit to expand their business and you think it's going to ruin you, you don't. It's not a direct financial interest, but obviously you do have an interest in the proceedings and should disclose that. Are there any familial relationships, and I would say also close friendships, between the decision maker and any of the parties at the hearing? Because again, we're asking ourselves, would someone, knowing that you are close friends with the applicant or that the applicant is your cousin, would someone think you're not going to be fair, that you're going to favor them? That you might not be fair, that you're going to favor them. You can be as fair as possible, and maybe you hate your cousin and you would just prefer to do anything that would make them unhappy, but someone could think that you might not be fair, and so you need to disclose familiar relationships and close friendships. You don't need to necessarily disclose if you know somebody enough to say hi, on the street. You know their name, you've said hi, something like that. But if you guys are going out to dinner together, if you vacation together, whatever, that kind of close friendship has to be disclosed. The next one, does the decision maker own or control property near the subject property? Is your property going to be specifically affected by this? Think about a development that is going to have a lot of traffic and it's going to all run by your house. Are you affected by the development? Do you have an appearance of fairness issue? The answer is yes, because there's going to be a tangible impact on you. The way I usually say is, as a rule of thumb, is when we notify people in a quasi-judicial proceeding, we notify property owners within a certain number of feet, who own property within a certain number of feet of the proposed development. If you're within that notice area, that means that we think you've got enough of an interest that you should know what's going on, and that's probably means that you need to disclose that at the hearing. If you're outside the notice area and you're just like everybody else, then we would look at specifics as to whether there was any specific impact of this development. Maybe you live a mile downstream from it and all the drainage is going right by your house, or something like that. We would have to look at that. But generally speaking, we're looking for a close connection. Yes, sir?
Is the city of Issaquah, is it still 300? 300?
Yes, it is 300 feet, and we actually this is our older version of this question, we've actually updated it to say, as indicated by receiving notice, just so that it's clear, because, for instance, the Urban Village Development Commission, all the commissioners would often disclose that they lived in Issaquah Highlands if there was a matter before them that was in Issaquah Highlands. And once we received the clarification that notice was a good indication of that, then that meant that not all of them felt they had to disclose that. Not that it's bad to disclose things.
The next one, has the decision maker made a final decision on the request before hearing any testimony or evidence? Obviously, if you have expressed opinions about a particular quasi-judicial matter and said that you've prejudged it, basically, and this is how you're going to vote before you've heard any of the evidence, that's a problem. You wouldn't want a judge who said that, and people don't want you in that situation. The last one, I think, is whether you have had any ex parte contacts. And ex parte just means you're having these contacts outside of the proceedings. So you're walking, let's say you're walking into the supermarket and someone comes up to you and says, I know that that project is on your agenda on Tuesday night and I want to tell you what I think about it, and proceeds to tell you. That's an ex parte contact. And ex parte contacts, in a way, are the best kind of appearance of fairness problems because they are easily cured. They are easily cured. And next slide, please. The cure for ex parte contacts is simply disclosing the substance of those contacts at the outset of the hearing. If at the outset of the hearing you say, I was in the supermarket the other day and Joe Smith came up to me and said that he hated this project and he thought that it was going to be a severe impact on wildlife in the area. And so I'm disclosing that Joe Smith said that to me. That gives fair notice to anyone who is going to come up and speak that somebody said that to you, and they can respond to it. If they don't know about it, they can't respond to it. So disclosing those types of comments, and you don't necessarily need to disclose, and I've been asked, do you need to disclose the name? Do you need to give the time? You don't necessarily need to do that, but you do need to disclose the substance of the communication. So as long as you do that at the outset of the hearing, that will allow people to respond to it, and it cures the appearance of fairness problem. Other appearance of fairness problems are not so easily cured. There are exceptions to the appearance of fairness doctrine, things like, would apply to you at this point, things like making statements during a campaign when you're running for office, because you're not sitting on an elected board, you're sitting on an appointed board, so that one wouldn't apply to you. But the other appearance of fairness problems are not so easily cured. You need to disclose them, you need to see if people object to you sitting, and sometimes people object based on things that you've disclosed, and it's not really an appearance of fairness problem. You sit there and you say, I've had this contact from Joe Smith, and he told me that he hated this project and that this was going to have an impact on wildlife, and someone gets up and says, I challenge you under the appearance of fairness doctrine, you have to step down. And you say, you get a ruling and say, no, he's disclosed, he or she has disclosed the contact, you have a chance to respond to it, not a valid objection. But other times when there is a valid objection, it is your cousin, you do have a financial interest in the property and so forth, we call upon the public and the people who are here, are there any objections? And if somebody objects, you will have to step down and you will have to leave the room and not participate any further in the proceedings. You can't contact the other members. You can't stand up and go, okay, now I want to testify against the project and stand at the podium and testify. That's been done. Yes, sir.
So as counsel for the city, would you recommend that you simply disclose and you allow the audience or someone from there to object, or would you just preeminently recuse yourself? It's just better to disclose and let it be challenged out in the open?
I would, yeah, I guess what I always tell council members and commission members who ask me is I always say, do you want to decide this? Do you feel you can be fair? Despite what you're telling me, do you feel you can be fair and do you want to participate? And if they say yes, then I say, just disclose and let somebody challenge you.
And what I would add is, call us ahead of time. It's a lot better to have us be able to consult with the city attorney or have the city attorney speak with you and hear the circumstances and help make that decision. I mean, you're all there because you want things to happen, and you want to represent the city well, and so it's easier to do that ahead of time than it is to do it in real time.
And if you feel you can be fair and you want to participate, there's no reason why you shouldn't. And I mean, that is, after all, your job as a commissioner. That's why you're on the commission, is to participate and make these decisions. But if you think, I'm second guessing myself, and I think I may not be fair, then you can recuse yourself.
And a couple of other things that aren't exactly ex parte, but are appearance of fairness. If there is an intermission during a public hearing, make sure you are not talking about anything to do with the permits. It's hard. You've been talking, listening, and then there's an intermission. And we had this happen where the commissioners did not think about it and kept talking about the permit during the intermission when we were out of the room, and we came back and the applicant's like, they've been talking about the application the whole time. So we had to ask, whether the applicant was comfortable continuing at that point. So it's hard because, many times you guys know each other well, you're very comfortable with each other. As I said, you're stopping a conversation for 5 or 10 minutes and then having to pick up again, and it just requires a kind of level of awareness.
Lucy, Jim, this ex parte discussion, informal, in the neat aisle of Safeway, is only relevant when it's not something that's already happened, it's history, the apartment complex is up. It's something that is either coming up or is at the next meeting. Is that correct?
Yeah.
So if it's already happened and people are buttonholing you saying, what
the heck were you thinking?
What's that?
Yeah,
That's
I'm sure you never get that, but no.
But that's
the
the
appearance
point.
of fairness doctrine only applies while the application is pending before you, and once the application has been decided by you, I usually, if there's a reconsideration period under your rules, I say it applies until you're done with reconsideration. But once that passes, then you can talk about it with anyone and everyone because you've done your job and it's done at that point. So it only applies from the time that the application is if it's something that is always going to go to you, like a matter that automatically goes to the Development Commission or the Policy Planning Commission or Planning Policy Commission. When it's filed, it is quasi-judicial from the moment it's filed until it comes before you. If it was like an appeal and it's a staff decision and then it gets appealed to you, it's quasi-judicial once it's appealed because then it's pending before you. So it's really only when the application is pending.
So if someone is talking to them because they know a permit is going to get submitted.
Right. I mean, technically, it's not pending, what I always recommend to commissioners is be cautious if you think something could come before you. Because again, even though someone is, talking to you and it's not technically pending before you, it could show prejudice or bias on your part if you participate in that conversation. And so I've always advised commissioners to say, I understand you want to talk to me. I think that's probably going to come before the commission. I don't feel comfortable talking with you about it. We'll have a hearing when it comes in front of the commission, and I encourage you to come and testify. And then I can hear everything you want to tell me. Okay.
Robin had a question.
Specifically regarding the Planning Policy Commission, I'm a new member, so I may have this entirely wrong, but my understanding is that that commission does not make decisions, it makes recommendations.
Yes.
So I see the word decision here, and are recommendations similar in the sense that all
Yes.
these rules
Yes.
apply?
Yes.
You're not getting quasi-judicial matters.
No.
Yeah.
Not, but
It would be
legislative,
if you were
would you
getting, yes, the same thing, the same rules apply whether it's a recommendation or an actual decision as the Policy Planning Commission. You do not get quasi-judicial matters, but at least not yet. One never knows. So you don't get them, so you probably will not have that issue of appearance of fairness and all of that before you. But the legislative matter, all of that still applies to recommendations as well as decisions. Okay, deliberations in quasi-judicial matters. Deliberations can occur immediately following the close of the hearing, or you can hold them over to a subsequent date. Sometimes you're just exhausted after a couple of hours of hearing and you say, I want to think about this. Can we postpone the deliberations to such and such a date? And that's perfectly fine. You don't have to decide it that night. The decision must be based on criteria in the code, and all of the applications that are in the code have criteria. Every level of review has criteria, and so you must make your decisions based on that. And lastly, the decision must be based on the record. That is, it must be based on the testimony you received in the quasi-judicial hearing and all of the documents and exhibits that were submitted. Again, that's a quasi-judicial matter. Legislative, you're free to take into account absolutely anything, whether it was presented to you in the hearing or not. Quasi-judicial, you're limited to the record. You have to make the decision like a judge would have to make it. I just have two last slides, and I had these in the last time I did this presentation, so I kept them in this time. There's two concepts, or a couple concepts that apply to what you do, and they're called procedural due process and substantive due process. Procedural due process is that parties must be given adequate notice and a meaningful opportunity to be heard. And we talked about that a little bit earlier, about how you give notice and how you give procedural due process. And that's because the Constitution of the United States guarantees procedural and substantive due process. So what we see when we violate that is we often see claims based on violation of civil rights. And so these things can ripen into a civil rights claim if we don't give people procedural due process. And procedural due process also means that the code has to be followed in terms of the procedures. Next slide. The other one is substantive due process. And substantive due process goes not to how you adopted the regulations, but what the regulations themselves say and do. Adopted regulations must be the basis for your decision. And and that's where the criteria that we talk about comes in, is that you need to use the criteria for making your decisions, even legislative decisions like comp plan amendments and development regulations. They have criteria in the code, and so you must use those criteria. Any condition that you impose in a quasi-judicial matter must be aimed at alleviating a public problem that is made worse by the proposal. Or if you're doing a legislative matter, you really need to, it's saying that you need to have some sort of issue that you're trying to solve with the legislation. that any condition you impose must use reasonable means of achieving its purpose. Same with legislation. You have to see that what it is that you are requiring people to do by enacting this regulation or by imposing this condition is reasonable to achieve the purpose that you're trying to achieve. And lastly, any condition you impose and any regulation you impose cannot be unduly oppressive. That's the language used, unduly oppressive. And what that means is that it cannot require someone to shoulder an economic burden that, in fairness, the public should bear. And for example, the courts have talked a lot about affordable housing and how affordable housing is a societal issue, according to the courts. It's not a development issue. So when developers are coming in and saying, I'm going to demolish this affordable housing project, the city of Seattle had regulations that said if you demolish it, you've got to replace it, or you've got to pay money into a fund to replace affordable housing. The Washington Supreme Court said, this is a societal burden. Homelessness, the need for affordable housing, it's a societal burden. It's not the burden of developers. Development doesn't cause a lack of affordable housing. Now, that's what the Supreme Court said. I think we all understand that if we build development that is not affordable, we will not get affordable housing. And there have been some moves on the legislative front to deal with affordable housing and to give you more authority to impose conditions. But in reality, what the courts look at in a substantive due process is, are you just being unfair to put an unfair burden on this individual as opposed to something that society should bear? So that's substantive due process. So that, I think, is the end of my presentation. Right close to on time. So any questions? This is my contact information. I am the city attorney, but I'm contracted to provide legal services to the city. So this is my contact information, and you can contact me. If you have more questions tonight, I'm happy to stick around and answer them. Yes, sir.
I have one for you on the role of public comment in quasi-judicial proceedings. Last year, several of us on Development Commission went to an optional training in North Bend presented by Washington Department of Commerce on some of these same issues. And in one of their slides, they said that decisions could be overruled or invalidated as arbitrary or capricious. And a few examples that they gave on that were ignoring evidence or making decisions based on a political agenda.
Yes.
But another one that they said was decision based on community desires, displeasure, or public sentiment or complaint.
Yes.
So I'm trying to reconcile the role of public comment in a quasi-judicial proceeding. We're hearing the public comment. Is that appropriate? Are we supposed to be able to distinguish between a comment and complaint or testimony of fact?
Well, again, in a quasi-judicial proceeding, you are applying your development criteria, your permit criteria, to the testimony that you receive. And what the rule is that you're talking about is that mere community displeasure cannot be the grounds for denying a permit. So if everybody just happens to dislike this proposal, that's not grounds for denying it. You can take public comment and community displeasure into account, but it cannot be the basis. You have to decide based on the criteria. Does it meet the criteria or it doesn't? And if you look at the criteria in a quasi-judicial matter, it doesn't say the public likes it or the public doesn't like it. It says it has to be consistent with the comprehensive plan, it has to be consistent with the development regulations and so forth. So going outside of that and saying, gee, the public really doesn't like this particular proposal in a quasi-judicial matter is not grounds for denial, and it will be overturned if that's what you base your decision making on.
And that's part of why when we write a staff report and we take all the public comments and we summarize the topics and try and put them in context, we're trying to say this one relates to this standard. this one, for instance, if they say this is just going to make traffic terrible, then we're going to say, what did the traffic study show? How does that relate to the standards of how roads have to be designed? It's part of the reason why we like to do the 2-meeting format, where we take all the commission and public comments at the first meeting and write you a briefing response memo, so we can put those in the context of standards, rules, all the things that Jim mentioned. We don't necessarily respond to every public comment. We're looking to the commissioners to say, we'd like you to tell us, what does this mean? That they don't like that all the buildings are going to be blue. And we can say, we don't regulate color in this part of town, or we do, and blue isn't allowed. So you can always put that back on staff and say, what does this comment mean in the context of this?
So if community displeasure is made in the form of evidence, if someone comes in and says, I don't like this project because, and they give you facts that you can then use to relate to the criteria, that's okay. The fact that the public comes in and says that. But if it's not a popularity contest, if the public says, well, I don't like this project, and it's ugly, and those kinds of things that you can't really quantify and relate to the standards, that's just mere community displeasure, and you can't make your decision based on that. Other questions?
For all the commissioners, this is Lucy's presentation.
So can I just ask, I know you guys are roasting in here. Dan, would you see if you can get that door open? And Kevin, could you try opening that door? I don't know if it'll make a difference, but we can pretend like it will.
It's all the hot air with the attorney speaking.
Yeah. So we have 2 brief presentations that we're going to make. One is just to give you some resources. So we're going to run through these. Let's see. Yes. So we don't really hand out paper codes anymore. So I want to give you a sense of where some of the regulations that you may want to look at. And Trish is going to chime in for things with Planning Policy Commission. Just for general, this is the main page of the city's website. Notify Me is a place you can sign up. This does not relate to any of your work, but it is a place to sign up for emails that the city distributes. And the new development is where we are showing projects that are happening in the city. Again, you are not supposed to be doing any research, but as an interested citizen separate from your quasi-judicial matters, you are certainly or with legislative matters, you're welcome to look at that part of the website. More specifically, and I'm sorry this is really small, if you select your government on the city's website, there are 3 pieces. There's the city code, there is the document center, and then the boards and commissions. So I'm going to show those in a little more detail, but you can click. This is the sort of starting point for any of those. So if you want to look at the city code and you click on that, it will take you to a list of all the Issaquah Municipal Code. Land use regulations are in Title 18, which is down here. And then you would get this sort of table of contents of the whole land use code. And so you would just click on them and you could find provisions there. We are not asking you to go do your own research, but you are of course welcome to look at the land use code, send us questions, try and understand the rules under which you're being asked to make a decision. Second is the document center. When you go to the document center, most of what you might need would be under development, and by clicking on one of these white arrows, it becomes black and expands. Central Issaquah is located there. The comprehensive plan is located there, and development agreements. We are actually this year underway to completely revamp Title 18 and integrate all the pieces into one single code rather than having all these separate pieces, which will make your and our lives a lot easier. But that won't get adopted until next year. So we have a little bit of time before. Anything else that you want to add?
No, all the highlights are there.
And then sometimes you guys have questions about board or commission meetings. If you, at the homepage, select boards or commissions, then you get a list. You get this page with a list down the side, and you could select Development or Planning Policy Commission, and this is what a typical page looks like. If you ever had to find it on your own, this sort of where the green box is at the top is the sort of path you would follow to getting there. But in that, on that page, the latest 3 packets are listed, or you could go to the Archive Center if you were trying to find a previous packet. You can see who your liaison is and email from there. You can see all the members and their terms, when the meetings are regularly held, and in what location. So just to give you access to information that you may be looking for. And if all else fails on the home page, use the search function. I hear it's actually pretty good, and we sometimes have to resort to it as well. So feel free to try that.
While you're there, we talked about watching the meeting on video, if you weren't able to be there, and could you show them the link where it would be?
Oh, well, let me go back up here. So one thing you can do, isn't it?
TV.
Yeah, so over here under meetings, it has ICTV 21. That's one way to get to it. Also, if you go to the Archive Center, it usually has the minutes, the packet, and the video available at the top.
But you can search council meetings, all of your meetings, and sometimes special events. They'll have, like the Salmon Days Parade or visiting the zoo or whatever. But that page is really a fun page, the TV page that has all the videos archived.
So, any questions about resources? It has the minutes. So,
did you just find us?
Are you watching us like in a live loop? So just quickly some sort of further context for the Development Commission. There are 3 types of permits that are specifically identified and come through the Development Commission. One is a site development permit, one is a master site plan, and another one is a development agreement. We're going to talk about those in a little more detail, about the review process at the commission for the new commissioners, and then some other new responsibilities that the commission has. So I'm not going to go into this in detail. You've got it. You're welcome to look at it. But you can see across the top, each of the permit types is listed. The triggers for each of these is listed. I would just point out that for site development permits, we have now updated one of the triggers, and almost every single street, not every street, but almost every single street in central Issaquah is a trigger. So even if you had a project that was less than 150,000 square feet on a site smaller than 3 acres, it will come to the Development Commission. And that was really realizing that some of the sites are small and yet very visible, and that is the kind of permit that the commission should and the public should have an opportunity to have a conversation about. As you can see, the role identifies whether you're making a recommendation or you're the decision maker, whether it's quasi-judicial or not. Development agreements go back and forth depending on how much property and property owner there is, so feel free to ask us if a development agreement comes before you. Your scope is generally the kinds of things that Jim identified, the comp plan, the development standards. listed in your purview is technical review. I just want to clarify that for our perspective, that is technical reviews associated with things in the land use code. So for instance, if you had questions about critical areas, because that is in Title 18, you have an opportunity to look at that. We do use wetland biologists, and we would tend to defer to them. But I think one of the things that sometimes comes up is street standards and traffic and those kinds of things. And that is a technical review that is outside of the land use code. And while you are confirming that we are complying with street standards, if there was a question, we would defer to the technical expert on traffic. And I
Can I just on that, some clarification?
Sure.
So, because almost every project now, traffic is an issue,
Right.
any size anyway, and we get kind of hung up on that a little bit. So when they're saying that they disagree with, the conclusions of the city that transportation impacts are negligible or appropriately mitigated, is the determination in front of the commission to agree or disagree with the conclusion of the city on the traffic mitigation or not? Did that make sense? Because it could be a point of dispute between an applicant, or a member of the public, or an organization in the public could come in with their own expert and dispute the city's conclusion. So how does that get resolved if it's not within the purview of the Development Commission? Because the development approval would trigger the traffic impact.
Right. I'm looking at Jim, who's very carefully studying the screen. My thought is that you are asking for the city to explain the basis from their technical expertise why you feel that this has been addressed, or to counteract that. I would add that. So we've never had someone else, the public, bring in their own technical expert. I hadn't really thought about that one. I do want to point out, I know that some of the commissioners are trained professionals, and you are not selected to act in that manner. Of course, that informs your perspective and your knowledge, but we have you on the commission as citizens rather than as technical experts. Jim?
Well, as far as what you do with that kind of testimony, if they do bring in their own traffic expert, then obviously you can consider that. If they simply say, I don't agree with what the expert says, and it's a quasi-judicial hearing, you have to give that what weight you would give a lay testimony against expert testimony. And presuming that it is within your criteria as to what you are deciding specifically, and yes, you can make a determination based on the traffic evidence in front of you as to whether it's good traffic evidence, credible traffic evidence, bad traffic evidence, whatever. And I have seen citizens hire their own traffic expert and bring them in. So it does happen sometimes.
What would our decision be? I mean, there's nothing in our criteria that's specific about this meets a traffic criteria, right? There's no.
Well, I think you'd have to look and see if you can relate it to one of your criteria. It depends on, what the criteria for each of these things, site development permit, master site plans, development agreement, what the criteria are, but the criteria are generally broad, and you do have the ability to relate it somehow to some of those criteria. Particularly, they're broad when they say things like that it has to be consistent with the comp plan, consistent with all of the development regulations, and so forth. And so, I think I would encourage you under those circumstances, if you do have issues and if staff has not taken those public comments and categorized them, as Lucy said, to ask the staff. So if we wanted to impose a condition based on traffic, which of our criteria would that fall under? And how should we analyze that? And staff, I'm sure, will give you their best recommendation on that.
And, you know, that is a really good point. You know, we're generally bringing things forward that we're recommending for approval. At the same time, we are here to support you. And so you might, at a meeting, hopefully the first meeting, so we had a chance to go away and work on it, say, you know, we have a concern about X, and we would like you to help us understand if we were to apply a condition, what are our options related, based in the code, related to this topic? We'd like you to bring that back to us next time. Now, we might come back and say, here are your 3 options. We still stand by our previous recommendation, or we don't recommend you do 1 and 2 for the following reasons. But, you know, it is absolutely appropriate for you to ask us to help support you in making the decision that you have every right to make, so long as it is based in the code.
And this ties into one thing that I talked about in the appearance of fairness, which is when I talked about ex parte comments, I talked about, you saw on the slide, I didn't really emphasize it, but they're ex parte comments from opponents or proponents of the project. Staff is neither. Staff isn't an opponent or proponent. They are your staff trying to assist you in making a decision. So in the normal situation where you have a quasi-judicial matter pending before you, the staff contacts do not fall within those ex parte contacts. I certainly think that whatever work product staff comes up with for you should be shared with the entire commission, so that the commission, all commission members have the same information, but it doesn't prevent you from calling staff and asking a question.
And I will just add that sometimes I think we sound like proponents because we are responsible for explaining the recommendation that we have made. So if we have recommended approval, we better be able to explain why we're recommending approval, which will make us sound like we're being proponents. But you have every right to ask us to help you craft something that is different than what we have recommended. And Brooke had her hand up earlier.
Oh, it's kind of worked itself out. I was wondering if there was an issue with the traffic, you guys would not recommend it for approval, correct?
No, but it is, you're right, if it was significant and we didn't feel we could address it through a condition. On the other hand, there is a perspective that the commission and the public bring of a different viewpoint that we may not have looked at. And that's why we have that conversation. You know, have you considered this, or doesn't it have to meet this? And when, you know, I look at some of the technical materials that you've provided us, it doesn't seem consistent with the criteria we have. You know, I mean, it's completely appropriate for you to ask us to explain. You know, we are kind of presenting an overview, and then you're going to tell us what you want us to explain in more detail. So I'm just going to kind of, for the some of the commissioners who haven't done this before, just kind of run through our land use process. We often start with informal meetings, then we go to more structured review, which includes both required and optional pieces, and then the commission piece. So the pieces where the commission is really involved is we get this site development permit or a plat submittal. Then we prepare a staff report which is sent to the commission, and then there are the development commission meetings. That is sort of the big the sort of nut of what we are asking the commission to be involved with. So if we kind of explode those or unpack that a bit, the staff report generally comes to you about a week in advance. We email it. The packet comes out electronically, usually first, followed by a paper packet. Most commissions do not get paper packets, but because we do not expect you to have big screens at home, we send you a set of paper plans and the packet just to facilitate your review. At the Development Commission, we have the the first part of the public hearing is staff and applicant giving an introduction to the project and hearing the commissioners and public's questions, comments, and concerns. Then we prepare a briefing response memo where we bundle the things that we've heard from you into topics. The staff provides a response, the applicant provides a response, and we give you a conclusion. That may be, this has already been addressed, it may be adding a condition, revising a condition. And then we come back for the conclusion of the public hearing to present what the briefing response memo, there's additional testimony, and then you are typically making a decision at that second meeting. Part of that decision is usually delegating to staff to prepare the notice of decision, which includes findings and conclusions, which is reviewed by and signed by the chairperson. And that's the actual decision that would initiate an appeal period. I just want to put on the Commission's radar that as part of the replacement regulations for Tallis and Issaquah Highlands, a new responsibility was added to the Development Commission, which is a community conference on preliminary plats. So that community conference would happen and then gives the public and the commission an opportunity to give input on the preliminary plat before it goes to the commission. We would do it in a sort of similar format in which we would hold the community conference in front of the Development Commission. We would prepare a memo that would sort of look at the topics that were raised, whether they have a grounding in code or not, and how that might inform recommended conditions or changes to the drawings. And that would be provided to any parties of record and the commissioners for additional comment, and then it would be finalized and be one of the attachments that goes to the hearing examiner. We're going to probably have one of these in the next month or two. So I just wanted to explain that new responsibility to the commissioners.
Just an observation, Lucy, on the initial, the land use review process and the land use review process, DC portion. This is just an observation, but I think the word collaboration generally has a pejorative connotation. I understand what it is, but is the collaboration between the city staff and the applicant?
Mm-hmm.
Well, all right, that seems to me that it could have, when it gets to the appearance of fairness, a negative pejorative connotation. I don't know what a better word would be, and I'd be glad to. That's
Robert Mueller.
So it's just, I would defer to Jim, but when we're talking about the appearance of fairness, and you got collaboration between the applicant and the city, it just doesn't sound right to me. And is there something like this for the Planning Policy Commission? I noticed that this is all DC.
Right, well, we did a lot of ours in the meeting before, right,
Okay.
with processing and how things
I
go
was in
through the.
Virginia, of
Right.
course.
You can watch the video.
All night.
So, and this is just I believe, the last slide, and I just wanted to describe some of the differences between a site development permit and a plat, because the level of information is going to be different than what many of the commissioners are familiar with. On the left is kind of an example where you're going to see a fairly detailed level of design showing, the layout, the elements, the materials. It may be at somewhat of a conceptual level. You might not see this is going to be a pine tree and this is going to be a maple tree, but you would have a sense of where trees, landscape, paving, maybe paving patterns, buildings, parking, all of that would be located. With a preliminary plat, this is a residential plat, but you would see the parcel lines, and you might only get enough information to determine that the parcels are sized appropriately. For instance, you might see this kind of road, this road classification is going into this tract that will be dedicated to the city, and you're confirming, yes, that tract is big enough to accommodate that road. Probably the most discretionary review that we have is around a park tract, because we don't, in most parts of town, have X square feet for this number of housing units. And so we're asking for a very high-level conceptual plan that gives a sense that that park can accommodate some reasonable uses to serve that plat. So it's going to be less detail. That's hard to get used to sometimes, and I just want to sort of put that on your radar. Any questions?
Curiosity, how often does a third meeting happen?
Not that often. I'm not, well.
One exception.
17th meeting. No, usually it's because either something comes up that can't be resolved at the second meeting, or we have occasionally had where the applicant has delayed a second meeting because they recognize that they're just not ready, and they'll ask to delay it until certain issues get worked through. Any other questions? Thank you all for coming this evening.
Well done.
Nice job.
Well done.
Back at you, Jim.
I need to know what the site development permit is. You know I've struggled with